we have some news when it comes to the fight that Jayz and Alex Spiro have been fighting and the war they've been raging when it comes to everything that's going on with Tony Busby and at the time 13-year-old who was allegedly assaulted in this lawsuit, right? Judge Torres now is letting everyone know and letting Jayz know that she's going to grant one of their motions. Which motion isn't? We're going to get into it here. Shout out to Megan Kuniv, who has been covering and updating us with documents on this trial. Make sure y'all go follow her and show her some love on X. And she has a YouTube channel as well. What does she say? She says Judge Torres has granted lawyer Alex Spiro's request to file a dismissal motion in the lawsuit that accuses Jayz of assaulting a 13-year-old girl in 2000. This is over the objection of the woman's lawyer, Tony Busby. The motion is due on February 6th. And I'm going to tell y'all right now, they're going to have everything done maybe today, definitely by next week. Let's see what is going on with this from Judge Torres. She says, the court has reviewed defendant Sean Carter's letter seeking leave to file a motion to dismiss the plaintiff's amended complaint and plaintiff's letter in opposition. Accordingly, Carter's request to file a motion to dismiss plaintiff's amended complaint is granted. All right, so this is a major win for Jayz. He's in there. So Judge Torres said, y'all can file this motion. I'm going to look at it, see what you have. And this thing might be thrown out. Oh, man. How do y'all think this is going to look for Tony Busby if this one gets thrown out? Just imagine for a second, you're one of Tony Busby's clients. And let's say you're an actual victim. Like you are legitimate. You have the story. You've got the pictures. You've got the videos. You have eyewitness testimony. And your lawyer is taking an L like this with a client that did an interview showing that and making it look like they lied, made them look bad. And now you've got a judge dismissing one of your most public, I mean, let's be real, one of his most public lawsuits so far. Man, not a great look for Tony Busby. And if you ask me my opinion, I think this is probably going to be thrown out, especially in light of everything that we've been able to see and the lack of evidence that was there. By February 6, 2025, Carter shall file his motion. By February 28, 2025, plaintiff shall file her opposition papers. And by March 14, 2025, Carter shall file his reply, if any. The clerk of court is respectfully directed to terminate the motion at number 55. So ordered, Annalisa Torres. All right. Now, we looked at this yesterday, and I want to talk about it one more time. This was where Alex Spiro previewed his arguments and his request. The judge's deciding dismissal motions are to assume the facts alleged are true, says Megan Kuniv. The arguments are about legal issues such as a statute of limitations. So let's go back through and look at this and see what they are saying when it comes to most of these motions, right? And as we know, Tony Busby did respond to this. Looks like he's losing the fight a little bit there. What do they say? All right, this is the email that was sent to Judge Torres by Jayz's representation. We write on behalf of defendant Sean Carter, pursuant to Rule 3A2 of Your Honor's individual practices in civil cases, to inform the court that Mr. Carter seeks to file a motion pursuant to Federal Rule of Civil Procedure 12B6 to dismiss the first amended complaint by Tony Busby, right? In accordance to Rule 3BI of Your Honor's rules, on December 19th, Mr. Carter sent a letter to the plaintiff setting forth the basis for this motion and advising that Mr. Carter would file the pre-motion letter if the plaintiff chose to stand on her FAC. All right. The plaintiff was required but failed to respond to Mr. Carter's letter within 5 business days by December 27th. Mr. Carter interprets the plaintiff's silence as confirmation that she will stand on the FAC as pled, which is why they're saying, Judge, let us move forward. And the judge says, yep, y'all can go ahead. Accordingly, Mr. Carter submits this pre-motion letter concerning his anticipated motion to dismiss, which will raise the following arguments. First off, the plaintiff cannot recover for her sole claim under the Victims of Gender Motivated Violence Protection Act, the GMV law, as a matter of law because the statute does not have retroactive effect. The plaintiff asserts a violation of the GMV law for conduct that purportedly occurred in September of 2000, but the GMV law was not enacted until December 19th of 2000, 3 months after the FAC claims. Boy, this is so bad. Oh man, Tony, what were you thinking, man? What else does it say? The claims the conduct occurred and cannot apply retroactively to create a cause of action unavailable to the plaintiff at the time in question. See Lewis v. some German name it looks like I can probably not pronounce. Dismissing GMV law claim related to the conduct that occurred before the GMV law was passed because the state does not provide for retroactive or immediate effectiveness, which makes sense, right? They also say contrary conclusion would violate both state and federal due process protections. And we know we do not want to do that. Second thing is, even if the GMV law had retroactive effect, it does not to prevail. Plaintiff must show that the violative conduct, never seen that word before, the violative conduct was committed within New York City. Interesting. But she's saying this happened in a house in New Jersey. Oh man. All right, here we go. Committed within New York City. Bass v. the Worldwide Wrestling Federation, ENT. And also they say Beverly v. the 1115 Health Benefits Fund. All right, what do they say? Only to acts occurring within the boundaries of New York City. The FAC alleges that the violative conduct is forced assault, we'll say, but does not assert that his conduct occurred in New York City, nor could it. Dang! According to the FAC, the plaintiff was driven from Radio City Music Hall to a large white residence with a gated U-shaped driveway, which we know now doesn't exist, right? A drive that took 20 minutes, according to the FAC, and they show it there in paragraph 43 through 44, which we read. This is where the alleged assault took place. The FAC's description of the residence in question, however, combined with public records, confirmed that any such residence, to the extent it existed at the time, would have been located outside the territorial boundaries of New York City. Man, this, I'm sorry. I know my rule is to wait until the evidence comes out, but if we're looking at this as it sits, this whole thing is a mess, and Tony Busby messed up. Because not only does the law they're trying to file this under not apply, according to Alex Spiro, but the assault that she's suing for took place out of this jurisdiction. So even if it did happen, which I don't know, maybe this is some type of admission of guilt, y'all, we'll let the plaintiff handle that. Even if it did happen, it happened outside of New York City, so this wouldn't apply in the first place, is basically what he's saying. This is looking bad. Third, they got a third thing. Any viable GMV law claims is time barred under New York City's Child Victims Act, or the CVA, which preempts plaintiff GMV law claim. The FAC alleges the conduct occurred 20 years ago, well outside the CVA's statute of limitations. Though the CVA was amended in 2019 to create a 2-year and 2-month revival period, the period expired on August 21st of 2021. CPLR 214G, plaintiff seeks to plead around the statute of limitations issue by asserting a claim under the GMV law, which contains a longer which contains a longer revival period. But again, even if you were to claim it, or even if you were to able to claim it under the GMV, it doesn't apply because this took place outside of New York City. What a mess, man. What a mess. Where were we at? I lost my place here. Which contains a longer revival period. Courts in this district, however, have recognized that the CVA's revival period preempts the GMV's law, overlapping an extended one. All right. And you can see Bellino v. Tallarico in 2024. The appeals were withdrawn in 2024. As such, the plaintiff's claim expired no later than August 2021. Thank you for your honor's consideration of this request. Respectfully submitted, Quinn Emanuel and Sullivan LLP. Signed by Alex Spiro. Oh man, Jayz might be taking home a win. A lot of people wanted to throw him under the bus for this one, but they've got some great case law and some great points in this as well. If it happened, which we know it didn't, the law that they're filing this lawsuit under, it doesn't even apply. And then there's the facts of the case, right? Which they didn't even get into here. I think they've beaten that dead horse, as they say. So it makes sense now after seeing this, why Judge Torres would say, yeah, y'all can go ahead and move forward. It'll be interesting to see what she decides on this. What do y'all think? If you were Judge Torres, what would you decide based on everything that we've seen so far? Whether that's the initial claim, the amended claim, the NBC interview, and all these memos that have come out from Jayz. I want to know what y'all think in the comments.